I'm the federal commissioner in Canada. We shared information with our UK colleagues, but we worked more formally with our provincial colleagues in British Columbia into this matter. And we are continuing our cooperation, particularly with respect to aggregate IQ. That investigation is still ongoing, so I'm not in a position to speak much about that case. In terms of how things turned out with the UK, I would say that our investigation in Canada was complementary to that of our UK colleagues. Our ICO colleagues focused rightly, because of the importance of the issues, on the use of the information for political purposes. In Canada, federally, with the exception of the province of British Columbia, political parties are not subject to privacy laws. That is very unfortunate. So we did not focus on that angle. We focused our investigation on Facebook's terms and conditions that made the Cambridge Analytica scandal possible, and we focused on the impact of these deficient standards for Canadians. I will note that this was not the first time that the federal office in Canada had investigated Facebook in relation to third-party applications. In a 2009 investigation, my predecessor, Jennifer Stoddard, and Elizabeth Denham, who was then Canada's Assistant Commissioner, raised numerous concerns about Facebook's privacy practices, very similar to what we saw a few years ago. And this Canadian investigation preceded a similar investigation by the US Federal Trade Commission, which led the Commission to adopt a consent decree. And if the rumor is correct, we may see Facebook having to pay a fine in the billion of dollars for potentially having violated that consent decree. So these facts are not new. They've been in existence for approximately 10 years. After initially disputing the OPC, my office's findings in 2009, Facebook undertook to implement at the time a privacy protection model that promised to deliver meaningful consent. And that they did not do that was very unfortunate because, in our view, with the benefit of hindsight, if Facebook had implemented the 2009 investigation's recommendations meaningfully, not superficially, the risk of unauthorized access and use of personal information by third-party applications could have been avoided or significantly mitigated. Instead, what we found in 2019 is that the privacy framework that Facebook had implemented was hollow. I called it an empty shell. Our investigation identified a number of issues with respect to accountability, consent, safeguards, and the ongoing impact on Canadians. The lack of responsibility taken by Facebook for protecting the personal information of its users, or in Canadian legal terms, the violation of the accountability principle of Canada's federal law, was probably the most troubling problem revealed by our investigation. Instead of being accountable, Facebook attempted to shift its responsibility to the applications on its platform, as well as users themselves. In fact, throughout our investigation, Facebook disputed and continues to dispute that it was even disclosing personal information to third-party applications. The company prefers to characterize what they're doing as, quote, making personal information available to apps at the request of Facebook users, end of quote. In addition to accountability, we made related findings about consent and safeguards. So in relation to one category of Facebook users, those installing third-party applications, Facebook relied on the fact that each app was required to post a hyperlink to a privacy policy. But Facebook did not actually verify that those policies provided sufficient information to obtain meaningful consent, or even that the link led to a privacy policy at all. Again, shifting responsibility to others, in this case, third-party app developers. Facebook did have a program to monitor compliance with its contractual protections by third-party app developers, but this program was superficial and ineffective, we found. Facebook was unable to give us one example where its monitoring program led to enforcement of privacy-related provisions of its contracts. By contrast, there were a number of enforcement activities in relation to copyright, for instance, but none in relation to privacy. For a different kind of Facebook users, the friends of installing users, Facebook relied on overbroad and conflicting language in its privacy communications. Consent was generally sought on registration of these friends in relation to disclosures that would occur years later to unknown apps for unknown purposes. Not quite meaningful consent in our view. So to address these problems, we made a number of recommendations to bring Facebook in compliance with Canadian law. Facebook, despite having engaged with us for weeks, if not months of discussions, refused at the end of the day to implement our recommendations, and as I say, even disputed our basic legal findings that they were disclosing information to third-party applications. As a result, the risks to Canadians and to others remain very high, including the risk that manifested itself in the US and the UK, that information would be used to influence how individual citizens would vote in elections. In Canada, we will have a federal election in October, and the fact that these terms and conditions exist and that Facebook is such a prominent social media, the dominant social media, is certainly a cause for concern in terms of the integrity of Canada's elections. Facebook's response at the end of the day was obviously very disappointing. The stark contradiction between their public promises to mend their ways on privacy and their refusal to address the serious problems that we identified or even acknowledge that it broke the law is another sign of a lack of accountability. And under the current state of affairs in Canada, so not only do we not have jackets in Canada, we don't even have order-making powers. I think I should have order-making powers before we buy jackets. So since I don't have order-making powers, my recourse, given the disagreement between ourselves and Facebook, is to take the matter to the Canadian Federal Court to seek an order to force the company to correct its privacy practices. Unfortunately, this is the only recourse that we have at this point. To every cloud, though, there is a silver lining, and there may actually be a few silver linings in the Facebook Cambridge Analytica matter. One is that individuals, as consumers, but importantly as well as citizens, now better understand the importance of privacy and data protection. And as a result, politicians acknowledge that the age of self-regulation is over, that stronger data protection and privacy laws are required. Here in Europe, of course, with the GDPR, Europe is a global leader in privacy regulation, but Canada, which used to be at the front of countries with strong data protection legislation, currently lags badly behind. And we can thank in Canada Mr. Zuckerberg for doing a great service in terms of public education. The government in Canada, which was very hesitant to legislate for many years, despite, I think, the obvious need to improve laws, is now taking notice and has made promises, published a white paper in March of this year indicating that after the next Parliament is elected in October, that we should see strengthened privacy laws in Canada. And of course, with an election comes some uncertainty as to which party will be in power after that election. But I think from discussions with all of the large parties that even if there's a change in government after the election, that we should see strengthened privacy legislation in Canada. Facebook also, of course, led to some very serious discussions in the United States about legislative reform, and I think that is a good thing. The picture in front of you is of the committee, self-styled the International Grand Committee on Big Data, Privacy and Democracy, which had its first meetings in London a few months ago, and they reconvened in Ottawa in the spring. This was an opportunity for a panel of parliamentarians from 7 countries, including the UK and Canada, to question tech giants, sometimes it's in their absence, including Facebook, about their practices. So I was a witness, among others, before this committee, and I talked then about the correlation between privacy and freedom and democracy, which at its heart, I think, is the biggest lesson that the Facebook Cambridge Analytica scandal has taught us. That scandal highlighted the unexpected uses to which personal information can be put and uncovered a privacy framework at Facebook that was, as I mentioned, an empty shell. It reminded, importantly, citizens that privacy is a fundamental right and a necessary precondition for the exercise of other fundamental rights, including democracy. This is why, as Canada enters a period of legislative reform, I will forcefully advocate for a rights-based privacy law. Privacy is often looked at in relatively technical terms of consent, access, transparency. These are important mechanical principles to enhance the right to privacy. In Canada, our federal legislation is based on 10 principles derived from the FAIR information privacy principles, including consent, transparency, accountability. These are very important mechanisms that support the protection of privacy, but they do not define the right itself. And I think legislation, in Canada at least, should define privacy in its broadest and true sense, such as freedom from unjustified surveillance. A Canadian senator introduced a bill to that effect in the early 2000s, and I think it may be time to reintroduce a concept like this in legislation. Another lesson, that will be my last point of the Facebook Cambridge Analytica matter, is that we need strong laws to ensure not only accountability, which is an important principle under Canadian law, but demonstrable accountability. The current law required Facebook to be accountable in relation to Cambridge Analytica, Kogan and company, but in fact it was not. And when we asked the company to undertake certain actions to demonstrate its accountability, it declined. We had weeks and months of discussions with Facebook, very polite, pleasant, diplomatic. Facebook claimed to understand our concerns, but at the end of the day, when came the time to actually comply and to voluntarily agree to certain measures that would demonstrate accountability, they declined. So the law, that's a perfect illustration, I think, for the fact that the law must not merely impose accountability obligations and then let organizations decide how they will comply. This is actually another form of self-regulation. The law must require companies to demonstrate their accountability. In the UK and in a number of countries, and I'm going to recommend that this be the case in Canada, this should include the authority for the Data Protection Authority to proactively inspect the practices of organizations and require them to demonstrate true accountability upon request. In this day and age, when business models are complicated, when data flows are complicated and if not opaque, you cannot rely on individuals to file complaints with the Data Protection Authority. The Data Protection Authority needs, based on its understanding of the industry, to be able to proactively inspect the practices of organizations, and only then, I think, would citizens have the trust that is required. Finally, in countries like Canada, where political parties are not subject to privacy laws, the scope of these laws must be broadened so as to ensure public trust in democratic processes.